Good afternoon, good morning. Welcome to Data and AI Live, wherever you're joining us in the world. Thank you very much for tuning in. Hope the session is going to be valuable for you. Today, we are going to be talking about how not to get sued when training AI models. Not just that as well. The title is slightly misleading because we're also going to be talking about how not to get sued when you're leveraging AI models that you might have purchased from a third party as well, which is as equally important. Um, and our guest today is Toby Bond. Let me just bring Toby in. Welcome, Toby.
Hello.
Um, Toby is a partner at global law firm Bird and Bird. He's a partner in their intellectual property group, and he's an expert in the law at the intersection of tech, data, and AI, and is an expert in AI copyright and AI disputes. So, welcome, Toby. We're very lucky to have you here today, and thanks for joining us.
Well, thanks so much for having me, and thanks for the invitation. I think it's going to be a fun discussion.
I think so. I hope so. I think there's a lot of questions that I hear in the market within this space, and it's certainly a grey area and an area that seems a bit of a tightrope. So yeah, look, I think hopefully this is going to be really, really valuable. How did you get into this space, out of interest?
Yeah, so I've been doing it for a while. It hasn't been quite as exciting or well as high profile, but I properly got into sort of AI and IP issues around sort of about 2017, and I sort of think that was so machine learning was getting pretty good in the mid 2010s, starting to surpass sort of human performance on image recognition, that sort of thing. And in about sort of 2017, we were seeing clients coming to us asking for advice around accessing data for particularly machine learning development, and that would usually have two flavors to it. Like some of it would be in the sort of data licensing space, and particularly there'd be like looking at existing agreements. So maybe you're a supplier, you want to use data you receive from customers for machine learning development. You'd be sort of looking at your agreements and trying to understand whether they permitted that use of data. And then the other one that was quite common and popular was sort of web scraping, and I think we'll talk a bit more at the end around the sort of the fun practicalities of web scraping. There's quite a lot of like, can we scrape this data? What are the legal risks? And a lot of that was being driven by sort of AI development in mind. So a lot of sort of data access, data ownership type issues, and that very sort of quickly converged with AI to sort of get me into this space. And I'm a sort of litigator by background, so I was always interested in the sort of contentious side and managing risk and actual disputes in this space. So no, it was sort of brought together my interest in AI and my interest in litigation.
Good stuff. Well, we're going to get into it shortly, but just some housekeeping so everyone knows and what we're going to go through. We're going to start by talking about the current, or Toby's going to talk us through the current litigation landscape, which is hotting up as we speak. Then we're going to move on and talk about future legislations that are incoming, what they mean for organisations moving forward, and then finally, towards the end, we're going to start talking about sort of practical tips and guidelines that organizations can use to protect themselves in this space. And then finally, at the end, there'll be plenty of time for a Q&A. So just with regards to questions, if anyone's got any questions as we go through, please put them in the comments box as soon as you think of them. We'll either bring them up as we go through, or Toby can answer them at the end in the Q&A. So any questions that come to your mind, please just stick them in the comments box. And just now, I'm kind of keen to get I guess, a straw poll of everyone that's online and listening to us. Can you put in the comments either if you or your organization is training AI models or leveraging third party models? So either put the word training or third party in the comments, please, just so we can get a kind of idea of what side of that fence that you're on. Great. Well, let's get into it then, Toby. Can you As we know, this space has been kind of all these legal wars have been hotting up, and I think they'll continue to
Mm,
do so. But can you give us, I don't know, like an overview of the current litigation landscape in AI?
yeah, absolutely. So I mean, I guess going back to the thing I said, like it's not new to have people sort of thinking about possible liability and disputes around the use of AI training data. That's sort of been around for a while, but I think it's really generative AI which has sort of driven the current push of litigation, and the reason we're all sort of seeing lots in the press around disputes in this place has been primarily driven by generative AI. But it does now also, the fact there's so much attention around generative AI sort of brings back attention to sort of classic machine learning and the use of data in that space as well. So although most of the litigation at the moment is focused on Gen AI, I think there is more attention now on use of data and machine learning as well. I mean, it's sort of it kicked off in about, so the first of the current wave of litigation was November 2022, and it was a class action in the Northern District of California in the US against GitHub Copilot. So it was code generation. We then had a little flurry of image generation lawsuits. We had a class action against a few of the image generators. We then had Getty Images suing Stability AI, the makers of Stable Diffusion in the UK and the US. And then since then, we've seen sort of a pretty regular pattern of litigation happening against primarily the big developers and the big sort of LLM providers and a few of the image generation providers. Pretty much all of it has been in the US. Pretty much all of it has either been sort of California or New York. Most of it has been sort of class action focused, although not all of it. And I'd say by far the most common sort of subject matter has been training on um, either books and more recently news content has been the sort of real focus. So it's primarily been LLMs, primarily been sort of text and books related. There's been, as I said, there's one case in the UK. There's been one case in China, but at the moment it's sort of the US. And I think we're up to about 26 lawsuits at the moment. So definitely, yeah, quite a lot happening in that space. At the moment, it has all been focused on the developers, like the big AI developers, and the claims so far have typically all had one sort of common element, and then some of them have had a few sort of additional extras. Like the core of these claims has been about the use of copyright works in the process of creating an LLM or some other form of generative AI model. So it's been claims about training, so the actual process of building the model. That's been common to all of them. Some of the claims have made allegations in relation to the trained model itself. So they've sort of been saying, well, actually, once you've trained it in some way, that trained model is a derivative work or somehow an infringement of copyright in the training data. Um, and then there's some of the claims have also been in relation to the sort of outputs from the systems. There's things saying that some stuff that comes out of these systems, so either the code, the images, the text, is itself an infringement of copyright in the works which were allegedly used in sort of training the system. So there's been sort of three buckets of claims. All of them have covered training. Some of them have or have not covered models and outputs. Yeah.
In your professional opinion, which of those three um, claims do you think the publishers are likely to get sort of best traction on?
Well, I mean, the easiest one for a sort of copyright owner to prove would be the sort of use in training. They just need to know that the data was in the training set, and they've been sort of scouring um, public technical papers, publications to see what data sets have been referenced, and then sort of working through that to work out whether their content was used. There's a really big debate in the US and the US copyright law because it has an exclusion to copyright for fair use of a copyright work. And there's a really big debate, really significant debate happening at the moment in these litigations about whether the use of copyright content to train AI models is considered fair use. That there's been case law in the past in the machine learning context, which has said things like using books to train a machine learning model is considered fair use or was in the particular circumstances there. The really big debate now is, does that apply to generative AI? Um, So it's sort of that's the claim that has been, it's easiest to bring. So you just say you've used our stuff, but there is a
Mm,
big discussion around whether it's covered, although that's the US, and copyright law does vary between different countries. So where you're training can make quite a big difference, which copyright law applies. Like copyright laws are national rights. So working out where you're doing stuff can be pretty relevant. I think the claims relating to models and outputs, they're a bit harder for the sort of publishers or the copyright owners to make, because saying a database of model weights is a derivative work of a book is quite hard to sort of understand how that argument works sort of technically and legally. And then with the outputs, it's quite not that common that the outputs look similar to pieces of training data. There's obviously a big sort of debate around that. So the training
mm,
ones are the easiest, but then have this exception that's pretty relevant in the US law.
yeah. The litigations that are happening, to what extent do you think they're purely financially driven, or uh, do you think the wider motivation is around ultimately protecting business models and livelihoods?
I think there's a whole mix of stuff in there. I mean, there's some people like creative, like artists, authors who feel really strongly that sort of AI is sort of usurping their creations and their rights, and they just feel this more for them as sort of moral feeling that their stuff's being used in a certain way. um, I think obviously if you're a large organization, like large industries, creative industries already have sort of structures in place, and whenever you see disruption um, to those business models, you do see the risk of litigation. When we saw it with Napster, when there was a new sort of online digital music, obviously Napster was doing it in a certain way that created disruption. It took a while for the industry to settle down and find a new sort of pattern and form. So I think there's definitely a sort of threat to existing frameworks in there as well. Um, there's also a flip side, which is actually for creatives. There's some amazing things you can do with these tools. Like they're actually really some possibilities that were just not possible before in terms of new creative content. And there's a big sort of, is it a threat? Is it an opportunity? So there's a lot of conversations happening. It's all playing out slightly differently in different industries, because sort of music, TV and film, publishing, journalism, they're all being impacted slightly differently. So it's a really sort of complex and fast moving space at the moment.
Yeah. And this might sound like a stupid question, but how can the publishers know that their content was used in the training of a certain model? So, for example, I think I know anyway. I think I'm aware that, I mean, for example, the OpenAI's training data set, I believe, is called the Pile, and consisted of, I don't know, 250,000 novels, various other things. Is it Common Crawl? I think the training data set that was used for, is it Gemini? I can't remember. Anyway, there's these huge data sets that are used, but to my understanding, the firms involved um, weren't transparent exactly what was in those data sets. So yeah, long story short, how do the publishers know that maybe their content was used?
Yeah, I mean that's a really big issue at the moment, is the issue around transparency, because there's obviously a like, publishers say, well, we need to know what content was used to train the model. The reason they want to know that is because if you use their stuff, they will say you can't use it without my permission. But then you obviously have the arguments about fair use under US law. Do you need permission in the first place? Um, there's also the sort of technical detail about how would you actually track view it through individual bits of content if you've trained on billions of data points. Like, how do you sort of track view individual things and understand it? And also a lot of the sort of competitive edge you may have if you're an LLM developer over your rivals would be exactly how you curate and manage and use the data at certain stages for certain trading processes. So it's pretty tricky to sort of work through how actually you work out what particular piece of data is being used in a training process. We'll come on in a minute to sort of the sort of future direction of legislation, but that transparency
Mm,
issue is definitely something that's out there. But there are issues around it in terms of practicality, and also yeah, sort of trade secrets and protection and things like that. So yeah,
yeah,
that's a really hot area of debate at the moment.
yeah. And we must move on to the next part shortly. But just one final question on this is: the current landscape is predominantly the big publishers litigating against the big tech companies and some big foundational model providers. Where does it, and maybe this might be a good segue into the next piece, but
Mm.
where does it go from here, and to what extent should smaller AI firms be cognizant of the dangers, and to what extent should maybe corporate organizations who are buying third party models be aware and cognizant of their abilities to potentially be litigated against?
Yeah, absolutely. I mean, you're right. At the moment, it is focused on the big developers, and I guess they're sort of the most obviously in public out there and doing things in disrupting business models. But if you look at some of the arguments that are being run in the litigations, and we talked about, there's obviously the claims relating to training. If it's just a pure sort of LLM and you're using it off the shelf, then you haven't trained it. But the line gets quite blurry when it comes to sort of fine tuning. So you may take a third party LLM and you may fine tune it in some way. There's obviously then thinking about the data you use for the fine tuning and also whether you're bringing in any risk if you take that model yourself. And then some of the arguments I mentioned, there's arguments relating to models themselves and relating to outputs. Now, if you're just a user of those models, you might be a bit concerned that if there's an allegation that an output from a model could be considered an infringement in some way, then if you're using the model, you could be exposing yourself to potential liability for sort of IP claims, and that is something which has come up quite a bit, and there has been a lot of sort of discussion around whether providers will offer you indemnity, IP indemnities. So, and a lot of the big players at the moment are currently offering IP indemnities. They say if you use the tool in accordance with sort of the criteria we say, like things you are and aren't supposed to do it, and you take these sort of steps to mitigate any risk, then if you're sued by a third party in relation to your use of our tool, we will indemnify you against that risk. So there's a sort of market
I
dynamic
see.
trying to reassure people, um, yeah, that
But
that
you'll
actually
need
is the
to
case.
prove that you've stayed within the guidelines that warrant
So
that indemnity.
yes, there's definitely
Yeah,
practical issues around how do you know that 5 years later someone comes to you because of an image or a bit of text you put on your website that was created 5 years ago. How do you sort of say, oh, actually, we generated that with this particular tool and that was covered by this indemnity at this time? And yes, we had. There are practical things. I think there's a general sort of positive. The developers want to stand behind this stuff, but there's obviously how does that work in practice remains to be seen.
yeah, yeah,
Um,
fantastic.
yeah.
Well, we've got to move on to next piece, which we're going to talk about future legislation now. But just for everyone listening, do get your questions in. If you just logged in, we're going to be having last sort of 5-10 minutes of the show. We're going to be doing a Q&A with Toby. So any questions, do please keep them coming and get them in. Yeah, well, let's talk about, so we've covered so far kind of the current landscape, Toby, in the first 15 minutes. But what of this is a very fast moving space, as we know, and we know there is future legislation on its way. Can you talk to us a little bit about that?
Yeah, so I guess there's a few ways this is coming up in terms of the way the world is changing. There's obviously the litigation landscape, which is run by its own dynamics, but you're right, the regulators, legislators are getting really involved in the space of AI technology, and there are sort of almost every day there's a new proposal or development um, in the space. I mean, the big two at the moment in terms of actual sort of legislation, which is sort of either in force or is pretty close to being enforced. So China was first when it came to generative AI. It has some provisional measures on generative AI technology, which is focused on the providers of generative AI solutions and imposes various obligations on them in relation to sort of use of data, mitigating risks, and that sort of thing. And that has actually come up in I sort of mentioned before. There's been one case in China, the Chinese court. That was a website who was offering API access to a third party model. It wasn't said in the decision whose model it was, but that website, if you put in it was Ultraman, a cartoon character. If you put in that name, it gave you images of something that looked like Ultraman, and the court held that was an infringement of the rights in Ultraman. And in reaching its decision, it referred to actually these new sort of Chinese piece of legislation around the obligations on generative AI developers and providers. So legislation there is actually becoming part of litigation. So that was China who were first with Gen AI. The EU is, like a lot of people will have heard of the EU AI Act. It is now very close to actually coming into force in the sense of being on the statute book. There is a staged implementation process.
Mm. It was passed last month or 2 months ago, was it?
Yeah, so I think it was approved by the council, the European Council, yesterday. Sort of because you have the Parliament and the Council and things like that. So it's now been
Right.
approved by everyone who needs to approve it. It in the sort of coming days, it's going to be published in the EU's official journal, and then I think there's a 20-day or something. Then there's a few days before it actually becomes law. But there is
Mm.
a phased implementation. The first trigger date is in 6 months. So at the end of
Right.
this year, there's going to be prohibited AI practices are going to be banned in 12 months' time. So June next year, we're going to have provisions for general purpose AI models. We then have another staged implementation for high risk models and things like that. So it sort of comes into force um, over a bit of time.
And are you aware of what like the headline bits are in that in the new EU Act and what organisations need to be aware of?
Yeah, so I mean, I guess going back to the transparency piece we were talking
Mm.
about earlier, the EU AI Act does impose on providers of general purpose AI models obligations relating to copyright law. They've got to have a policy to comply with EU copyright law, and that includes respecting. So under EU copyright law, you can use copyright works for text and data mining, which is generally considered to include AI training for commercial purposes, as long as the rights holder hasn't opted out. And there's a big debate around what an opt out looks like, how effective it is, that sort of thing. But if basically the new law is going to require you to have a policy to comply with opt outs and show how you're complying with those opt outs from rights holders. And also, you've got an obligation to disclose the content that you've used for training. And there's been a big debate around what level of granularity. Like if you've used a billion things, you're not going to have a list that's a billion items long, but it sort of talks about a sufficiently detailed summary. And the examples given are like listing the main data collections or sets that went into training the model and the sort of large public and private databases. There's going to be a code of practice, which is expected sort of Q2 next year in terms of what you need to do. And it's also if you are fine tuning a general purpose model, you will have an obligation to disclose the data you've used for fine tuning, but not for the like you obviously you didn't do the original training, but you do have to disclose what you used for fine tuning. If the thing you're doing is a general purpose model, and you might then say, well, what's a general purpose model? It's basically something trained on data at scale, which has lots of different purposes. It's pretty much like an LLM is very likely to be a general purpose model. There are other things where it may be more borderline, but if you're training an LLM, you need to be thinking about this sort of a transparency obligation if there's some connection with the EU in what you're doing.
Yeah, and to me there seems to be parallels between this and Customer Data Act GDPR of 2018. Am I right to see those parallels?
It
Are
yeah,
there sort of things that are common?
it's I mean definitely the way of thinking, some of the types of language which are used in the AI Act are common. I mean, the AI Act is sort of like a bit of product safety legislation, but it's sort of grown in these interesting ways as it's gone through the legislative process to sort of be more of a GDPR like piece of legislation. It has a similar sort of like the penalties under it are similar to GDPR in the sense they are sort of a number of million euros or a percentage of global turnover. So
Right.
the sanctions for non-compliance potentially quite serious. I mean, it's also worth like GDPR is still going to apply if you're developing AI models, um, and so you need to be thinking about if you're using personal data in model training, what's your lawful basis for the use of that data? And one of the hot topics has been if you're using scraped data, so data scraped from the public internet, what's your legitimate basis for using that data for AI training? That and various sort of the data protection authorities like the UK, France, the Netherlands have been issuing guidance on how they interpret GDPR when it comes to scraping personal data online for training. So although it's not quite the same sort of like litigation for copyright stuff, there's definitely a sort of liability surface there in relation to the use of personal data, which needs to be managed.
Yeah. And just you referenced it there, and I was going to ask you anyway about the penalties. So what? Because I guess a lot of people are listening to this and interested in this topic. They're ultimately probably going to be interested in what those penalties look like and the potential risks. So they sounded fairly penal, given what you said a minute ago. But yeah, can you unpack those potential penalties for us a little further?
Yeah, a little bit. So there's a sort of a few different penalties depending on what you've been doing under the EU AI Act. I mean, if you put into place one of the prohibited AI practices, so the sort of things that the EU thinks so dangerous you can't use it in the EU, and that's things like so the like facial recognition databases. So there was a big, some people will have heard of sort of the Clearview AI saga, um, and how that played out, and Clearview being fined by a lot of the European data protection authorities. That type of practice is very clearly sort of prohibited in the EU AI Act, and if you're engaged in that, then there are fines of up to 35 million euros or 7% of your worldwide turnover. So that's like pretty big slap on the wrist for doing it. I think in the UK, Clearview were fined £7 million, but then they appealed and they won on appeal, and now there's a further appeal, and it's all about whether they're actually in scope of UK GDPR. But yeah, anyway, so to pretty significant fines for those privacy practices. Everything else, so I guess that would include sort of non-compliance with the copyright disclosure provisions, fines of 50 million euros or 3% of worldwide turnover. So not quite as significant as GDPR, but still sort of things to be sort of concerned about, and obviously the reputational harm of being fined. And then there is also a fine for giving misleading information to the EU AI office and sort of national enforcement bodies. That's 7.5 million and 1% of worldwide turnover. So there's
Right.
sort of some relatively chunky penalties in there.
Okay.
Um,
Yeah. It sounds like they are. Yeah. Pretty chunky. Is the description. So I guess bottom line, this is not something organisations should be taking too lightly, because those fines can be pretty penal.
yeah, but it's still, I'd say with the AI Act, it's very much a sort of like you have the legislation, but then there's be all these codes of practice and standards and things which are still being developed. So there's a lot of work still being done to actually sort of work out the specific details. But it's a great time now to start thinking about whether you're going to be impacted, how you're going to be impacted, and what steps you need to take to comply. Thinking about the sort of staged guidelines. There's also sort of grandfathering clauses. So if you've got machine learning systems on the market now, like they may not need to comply if you don't make any substantial modifications to them after I think sort of June 2026. So there's sort of you may be okay, but then if you change them, you may not. So it's a yeah
There's
bit
a
of a
laying
thicket
off
to work through.
period.
Yeah,
Yeah. Yeah.
yeah.
Absolutely. Yeah. As you say, I mean, I guess there is a grey area to some extent, but this might be a nice segue into our next piece, which is worth doing. I guess everything you can do to avoid a potential litigation. Um, should we move on to sort of practical
Yeah, I
tips,
think
Toby? Unless there's
that's
anything
the
else you want to say about
no. I mean, I guess I
AI
say
legislation that's
I mean,
coming.
I say that also, like I've talked most about the EU and China. Also, there's stuff
Mm.
like potentially happening in the UK. There was talk in the FT over the weekend about possible transparency requirements in the UK. There's a bill before the US legislature at the moment around transparency issues. There's lots of states in the US coming up with their own legislative proposals. Canada's got something in the pipeline. There's just a whole world of stuff coming up now, and sort of working out what's relevant to you, how it's going to impact you.
On that, then, I do want to move on to the next piece, but this is so interesting. I think it's worth asking the question: what if you're an organisation that is looking to sell uh, either your own AI model or something you built on top of across multiple geographies? Is that going to be as complex as it sounds, given that all the regulations are going to be slightly different, or is there any way around
I mean,
that,
that
you think?
that is the key question. I've been discussing this with quite a lot of clients at the moment, is how do they manage this sort of complex, varying landscape? I mean, we've seen a bit of GDPR. There was sort of people talk about the Brussels effect of sort of organizations who operate in the EU and beyond actually just saying, well, it's just easier to have one system and one approach and just apply GDPR principles in the way we deal with personal data, even when those activities would actually be outside of its scope. You possibly might see that with the EU AI Act, but then you also might see people saying, well, actually, I don't want to. There are things in there I don't like, so I'm going to actually split my. I've even heard talk of splitting services and saying I'm going to offer one version of a service in the EU, and I'm going to offer other versions of the service outside the EU because I just don't. If I don't want those compliance obligations, so I think each organisation will be different. One approach is just to go to the highest level of regulation and apply it globally, but then you may lose some opportunities that you would get from actually sort of taking advantage of the differing regulatory environment.
Yeah, yeah, yeah. Great, thanks for that. I think that's a topic probably we could do a whole another episode on, but we
Yeah,
must move on. So let's move on and talk about practical tips. Before we do that, reminder to anyone that's just tuning in, we're doing Q&A probably in about 10 minutes with Toby, so do get your questions in. Um, so, Toby, if you're an organization, you're training AI models or fine-tuning AI models, what are the and you're maybe concerned, not quite sure what to do. What are the sort of the key, I guess, practical things then that you could be thinking about doing right now to make sure you're compliant?
yeah, absolutely. And for me, the key thing is sort of having a data management process, and just thinking about how data comes into your organization, how it gets used within the organization, and then also to some extent how it gets disclosed beyond the organization, and in what form and for what products and services, and just having that sort of overview, and understanding how you manage the legal risks that can be engaged through accessing, using, and disclosing data. That, I mean, that's a really high level sort of broad statement, but that's the sort of key thing. I mean, one thing I like to say is it's a good conceptual model because a lot of people will have gone through this process before, is thinking about open source software, because it's a bit similar in some way because it's some content, which may have some legal risks in it that you may bring into the organization and use, and if you use it in inappropriate way or use the wrong stuff, that could give rise to liability. So actually, if you're thinking about like what policy documents or whatever should I have in place, like actually looking at your open source policy, if you have one, like will actually give you quite a good sort of conceptual framework, and thinking very much about like what's your inbound process for bringing it into the organization. Um, what's your use process? So what are people allowed to do with it? What are there particular things they are allowed to use it for or not use it for? And then what's your sort of outbound service delivery based on that stuff you've brought in? Like, are there things you're willing to do and not willing to do? That sort of thing. And I think one thing that every time I hear the term data lake, I do a little shiver as a lawyer. I know, like, if I'm a sort of data scientist, like data lakes are awesome, and
I think a lot of people shiver when they hear data lake, not just
yeah,
lawyers.
it's sort of the thing that slightly terrifies me is like you're mixing things, some of which may be absolutely fine and brilliant and all good, other bits of which may have sort of significant liability risks associated with them. And if you just chuck it all in together, it all goes a bit muddy and brown, and it's really hard to then use that stuff in a way where you don't become infected with the risk of the sort of data you've ingested, which does, maybe it's subject to third party IP rights, or you brought it in subject to restrictive contractual terms which only allowed it for a certain purpose, or there's personal data in there and there's a big personal data risk in sort of using it. So that sort of that mixing together, it can be risky from a legal perspective. I guess the alternative is you have a whole bunch of silos, which isn't ideal in some spaces, but it may be actually just trying to sort of triage what you bring in, knowing what you do with it can be quite important.
So if you're an organization that's more federated in the way it leverages its data, it might be slightly easier. Whereas if you're maybe still your operating model is more of a center of excellence, big muddy data lakes, as you say, it might be a little more tricky.
Yeah, I mean, it's always a sort of conversation. Like you're sort of thinking about, well, who within the organization has ownership of these sorts of issues, and like, it, yes, it could be sort of like CIOs, legal teams, privacy people, but it can't always just be them. It has to be somewhere within the business, the people actually who are on the coalface of thinking about using this stuff. And I always think it's a sort of conversation between the two. It's sort of a bit of an education of people in the business by the sort of lawyers and privacy professionals about what's likely to be more risky and less risky, and when you need to go and get some advice, and also a bit of sort of education by the business for the legal teams and the privacy professionals about the sorts of things we want to use, the sorts of things we have, what terms it comes in under, because that allow, if you have those relationships and you sort of, the conversations have been had already, it allows you to sort of move more quickly than if you're sort of like, the worst thing. I mean, I was speaking as a lawyer, that the worst situation is we've got this amazing AI based solution. We're about to launch it next week. It's going to be brilliant. Can you just make sure, like, but we have trained it on this data. We're not quite sure that we've just realized there may be some issues. Someone's asked a question and gone, actually, were we allowed to use that data? And then as a lawyer, you're having to do a really hard thing, which is like make a risk based decision that's like the commercial opportunity versus the sort of liability and litigation risk of launching. If you've
Right.
had those conversations a lot earlier and you've been able to input and develop and build, like maybe the team came to you a lot earlier, or maybe you knew to go and speak to that, it just makes the conversation a lot better and more productive than
So
sort of.
specifically, then, what are the interactions that need to happen earlier? Is that CIO, legal counsel, privacy people within an organization interacting with developers and engineers
So
who are building these
yeah,
products and talking about the data that they're going to bring in to do that? Is it that, or are there other
I think there's
interactions that are
a few
important?
things. So I think there's a bit of a just sort of like an education, know-how, relationship building piece, which is a bit soft and fluffy, but it's never a bad thing for the you to know who the relevant people in the organization are and sort of have speak to them on a relatively regular basis. I think there's then a sort of business process side to it. So I've seen some organizations where they have quite a formalized like data reuse policy. So if you are a developer and you want to reuse a data set the organization holds for a new purpose or a new project, you have to, I don't know, fill in a form, send it to the legal team, or something like that, which allows a sort of triage and analysis process to happen. Now that's not going to be right for every organization. It may be a bit stifling, but it is one way of managing that sort of issue. And another way I've seen organizations deal with it is sort of appointing internal owners for data sources. So if you do have sort of quite big, important sources of data, just having a person or a small group of people in the business who understand that data source, where it comes from, what the rights and restrictions are for using it, and if you ever need to use it, you go and ask them, and they can tell you. And it's
Yeah,
yeah, you're not ferreting around for whatever contract you've signed 5 years ago that everyone's lost and actually didn't sign, and no one knows if it applies.
yeah, yeah. So it's having systems and processes in
Yeah,
place. You sent me, and it might be, maybe this is relevant to bring up now, but before we came on air live, you sent me this sort of data management framework. Um,
yeah,
which is this something that is contextual depending on the organization, or is this a sort of framework that you'd recommend could be applied
yeah.
across the organization?
And it's trying to sort of, it was trying to be sort of high level and covering a broad, like how data comes into organizations and the things you might want to think about. It will, obviously every organization is different in the way they structure themselves, but I think the sort of what's your inbound process, thinking about um yeah, how you track and manage rights and restrictions and those sorts of things, is always going to be a positive thing for sort of any organization. And there's also a sort of proactive, like actually thinking about um, try and standardize the way you bring in data. So a classic one would be if you're a supplier and you want to be reusing customer data in some way, like trying to bring all your customers onto the same paper that they're contracting with you on, because that at least then gives you a broader pool of stuff to play with, where you know it all applies rather than just infinite slices of stuff. So that's a sort of inbound process thinking and sort of a forward-looking approach, which I think is useful. Definitely, then the use process. I've been talking a bit about the sort of internal owners, business process for use and education. That's all good stuff. And then yeah, things about retention and outbound. I think they're all pretty general, but this is just one way of thinking about it. Um, there are lots of other ways, but it's sort of just to me that this is I've seen this type of model work in organisations, and it is can be quite challenging. Like it's quite a lot of work, and you're not quite sure which stakeholders are involved, and it's one of those sort of long-term plays. Um, but I think the sort of potential of AI technology to generate value for the organisation is really focusing attention on this type of stuff, and sort of rather than just fighting fires in each individual project, be sort of trying to move towards a bit more of a sort of holistic approach.
Yeah, yeah, absolutely. And I think Alex has just made a comment about this. This is called federated data governance. Is one of the best ways to regulate data ownership uses within an enterprise. And I guess from a talent perspective, one of the things that we're seeing, which I think is a good thing, Gen AI has really highlighted the specialisms of data governance and data management. And from a talent perspective, we're certainly seeing that play out in terms of talent requirements within organizations, which I think is a great thing. Um, let's move on to Q&A now, Toby. But just before I've got a couple of questions actually, which I'd be keen to ask. So
Sure.
before we move on to anything else, but just if anyone's got any last minute questions, please get them in the comments because we'll be taking external questions very shortly. But one of the things that I was sort of wanted to ask you, Toby, was I remember very well going back to 2018, the GDPR laws that came in, and at the time I guess the tension that existed between organisations who wanted to do valuable and interesting things with customer data, but also customers not wanting their or being concerned about their data being used. So is the situation now very similar to that? And how can organizations best go about managing any potential tensions that exist in that regard?
Yeah, I think you're absolutely right. There is, and there's always been a bit of tension. I mean, obviously, personal data. There's always been that sort of concern, and GDPR went away to sort of keep giving a framework and reassurance to consumers and things like things like that about how their data is going to be used. There's always on the sort of business to business basis been sort of nervousness about use of data you give to a supplier for other purposes, and that we saw that bit of that with machine learning. And that's the stuff I was doing in sort of 2017, 2018, was sort of advising on the contractual terms there. I think we've just seen a sort of 10x, maybe even 100x sort of focus on that issue with Gen AI. Like it's put a lot of focus on that. Customers getting really concerned about, like, especially things like change in terms of service. I think there was one reported, I think it was Slack was reported a couple of days ago, have changed terms of service or in some way which permits AI training, and there's sort of been a bit of sort of fallout around that. So it's definitely an issue which is getting our attention. I mean, in terms of
Why? Is that because Slack did that in a way that was not too transparent?
I mean, I think they well. So I've just read on LinkedIn that people reporting. I haven't actually read the terms of service themselves, but I think people just concerned about um, the potential for their data to be used. I mean, going to sort of how you manage those issues, like the experience I've had, um, is that you can actually turn it into a productive conversation with customers if you explain the value that they're going to receive as a result of use of um, their data for sort of AI um, training. And it's very much like you will get this additional service, or you will have a better service if your data is used for development of a sort of community model which everyone shares in, because you get the benefits of everyone else contributing their data. And I've seen organizations say that you've got two options. You can have a model bespoke to you. It's vanilla, it's built on your data, it's not built on anyone else's, it's all yours. That's great, but it won't be as good as this other one. And it all depends on the industry. In some contexts, people sort of really see the value of having a sort of a broader data set. I mean, things like fraud detection, like you want to be able to detect as much fraud as possible, and the types of fraud you see on your system, you may not be able to predict new and emerging trends. But if you have a model built across lots of customers may feel more comfortable to contribute because they can see the value and be able to have a model which picks up new and emerging trends really quickly. So it's that sort of like the value conversation. So it's, yeah, the earlier those conversations are had, the better. But that's just one way of achieving it, is talking about value to customers.
Yeah. Okay. Um, Indu has asked, should highly regulated sectors stay clear of Gen AI until there's greater clarity on the legal front?
I mean, I don't think. I mean, my experience has been like there are people in highly regulated sectors who are really excited about this technology, but I think the fact you are highly regulated adds an extra layer of complexity to your engagement with the technology because you have other obligations as well beyond just the sort of AI specific laws which are starting to emerge. I mean, you definitely see nervousness in industries which have duties of confidentiality to their clients, so law firms included, about using third party external LLMs and disclosing client data outside organizations. That's not something, if you work in that sort of industry, you want to be doing. But the solution to that may be a private tenant model where there's no data going beyond your secured infrastructure and there's no training which could benefit anyone else. So the industry is moving to sort of respond to some of the concerns. And I know some of the big providers are focusing on highly regulated industries and explaining how they can address some of the concerns, particularly around information security, um, privacy, those types of things. So I think it's sort of not quite black and white, but obviously if you are in a regulated industry, there are additional things you need to really think about.
Yeah. Yeah. Um, Another quick one for me. I wanted to touch back on something we touched on 15 minutes ago, but it was around if you're an organization, how do you manage risk when you're buying in an A? So if you're not developing it, but you're buying in an AI model, you mentioned that certain model providers are providing sort of indemnity, sort of risk insurance, essentially,
Yeah,
if you
yeah,
follow their guidelines. But if if there isn't that in place, how can you manage that risk if you're buying in an AI model? What are the other ways that you could
yeah.
look at?
I mean, it all sort of comes down to like, what are you going to be using it for? How likely is that to result in something which could be alleged to be an IP infringement? I mean, we've been focusing on IP infringement, so I guess go with that. But there are of course other risks of using these things like hallucinations, incorrect results, bias, all those sorts of things as well. But I guess it's sort of how you're going to be using it, for what purpose, how visible is that going to be to the public? Like if you're bringing in something to create your new marketing campaign that's going to be splashed all over the internet, and there is a possible risk that the content which is generated could contain third party IP, and you don't have a process to spot that and mitigate the risk of it going on your website, and then you launch a product based on it, then like that could be quite a bad outcome. But if you're just buying in a model to do some internal like knowledge management, RAG for IT service support, that sort of thing, like probably not as concerning. So it's a very always a sort of like, actually, what are you doing? What's the risk? How much does it matter? And these are very, at the moment, everyone's just trying to get a sense of, for particular use cases, what are the issues likely to be. Obviously, if you can get some contractual protection from your supplier, that would be brilliant. The thing we're seeing coming up quite a lot at the moment is a lot of sort of SaaS solution providers are building on top of third-party foundation models and LLMs. So they're taking the
Mm,
model, they're fine-tuning, they're building a service around it,
yeah.
um, and they're then offering that to their customers. Now there are two things there, which is firstly there may be a sort of indemnity from the LLM provider to the SaaS solution provider, but that doesn't cover the customer's use of it because it's only covers the use by the immediate purchaser of the thing. At the moment, that's typically how it works. So if you're a SaaS provider, you then have to work out, well, are you going to offer your own indemnity to your customers? So that's a conversation that's happening a lot at the moment. And then the second one is you what you're probably doing is taking an existing SaaS platform and adding some new functionality to it. So you're not just an entirely new service. You're taking a thing, maybe putting in a text box to allow interaction with an LLM within the context of your platform. You probably already get some terms and conditions in place for that, but you're introducing into it a new technology with a different risk profile. So if you're the SaaS solution provider, you'll want to probably put new terms in and manage the risk in a slightly different way. Maybe you don't want to offer the same indemnity you did for the rest of your platform, especially where you haven't built some of it. Um, But then how do you manage that contractual change process? That a lot of that's happening at the moment. People are trying to work out, well, we need some new terms. How do we put them in place? How's it going to work? Is it going to be opt in or opt out for customers? Like, do we actually, like, a lot of customers now have their own AI governance policies, and they may sort of
Mm.
prohibit employees from using generative AI technology. Do you want to just switch on by default for all your users a bit of generative AI in a platform? Could that mean the organization, if it followed its own policies, should no longer use your platform? Do you want to allow some sort of opt in, opt out, and sort of granulated thing? So yeah, loads happening in that
It's
space at the moment.
it's very complex by the sounds of it. I'm sure it'll all get sorted out eventually, but I'd imagine the next few years may be quite messy.
Yeah.
The we're coming to an end now. Sadly, time is against us, and we're running out of time. But what I'd like to finish with, Toby, is if someone's just tuning in right now, they've seen nothing of the last 50 minutes of our conversation. They run an AI organization that's building AI models, or leveraging AI models. What is just the one thing, if they're just going to watch this for 30 seconds or a minute, what's your top tip that you'd give them to start thinking about right now?
Yeah, I mean, I'd say the more robust your data management and governance process is, the better you're going to be able to manage and understand the risks in AI training. So for me, that's absolutely key. How you manage data is the fundamental of AI development risk management.
Great way to finish. Toby, thank you very much for today. This has been absolutely fantastic. Some brilliant insights that we've had. If anyone wants to get in touch with you, what's the best way to do that?
So that would be toby.bond at twobirds.com, or just Google twobirds.com and find my profile and drop me a line.
Great stuff. Toby, thanks again. This has been fantastic. And thanks everyone for tuning in, and we'll see you again next time.
Thanks so much.